Hi, Cora. Hi, Kay. Kay's not here yet. Guess it's just Cora. Thank you for coming, Cora, and for arriving early. I'm going to share it to a few places now, if you'll excuse me, and then I'll join you. Hi, Steve. Hi, Cheyenne. Be with you in a minute. Still sharing a bit. Please do share for me as well. Okay, I'm about to join you. Hello, everybody. Hi, Dolores. Hi, Dale. Hi, Cheyenne. And Cora and Susan. And Cheyenne said she shared to Venus and Neptune. Anybody prepared to give the fish sign? Hey, Susan, how are you tonight? And Dolores, thank you for joining and for sharing. Okay, thanks to everybody. Okay, so tonight's a continuation of what I did on Thursday when I talked about the about day one agenda, the article by and special issue of the American Prospect. The article I talked about was the lead article in that issue, which was by Dave Batayan, and that kind of summarized the idea behind the day one agenda. Have we got any echo problems, by the way, at this point? Now's the time to let me know if I've got any. Yeah, glad to see you too, Kay. Okay, so I went through the day one agenda last time, and you could see all the possibilities in it. And it appeared, I believe, if I recall correctly, on September 23rd. Recently, actually, on December 1st of 2019, there was a reply article in Jacobin by Ryan Dorfler, Doerfler. It was called Executive Orders and Smart Lawyers Won't Save Us. And it was a reply and a critique to Dave's article. And let me share the page with you. And there you should be able to see the picture of some Supreme Court people. John Roberts. Oh, well, there's Elena Kagan right there, and Neil Gorsuch, and Brett Kavanaugh, who were attending Donald Trump's State of the Union. Not looking overly happy, I may say. They seem a little grim, except for Kagan, and I can't imagine what she's smiling at, but there she is. Actually, this was in 2000, on February 5th, 2019, in the House, when Trump was delivering his State of the Union. And Ryan Dorfler says in that article, it's news to no one that Congress is broken, owing to partisan deadlock and supermajoritarian rules, including the filibuster and equal apportionment of the Senate. Our legislature is largely incapable of addressing our national, let alone international problems, from immigration to climate to guns. The odds of comprehensive legislation are basically zero. And while one can hope for modest reforms, even there the emphasis is on hope. And Ryan says, given the state of dysfunction, it's natural to look for alternatives. It should come as no surprise then that we get appeals to the states to take the lead on energy efficiency and to private employers to help to reduce income inequality. Most loudly, though, we hear pleas to the most prominent actor within our political system, the president, to, quote, get something done, unquote, on this issue or that. As a result, much of the story of the contemporary presidency has consisted of attempts to implement national policies in Congress's stead, whether in the form of President Obama's deferred action programs or President Trump's um, 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 the border wall, immigration, Obama's Clean Power Plan, climate, or various proposed and actual executive orders by Presidents Obama and Trump in response to mass shootings, guns. Support for executive action varies by partisan affiliation and current White House occupant. And so, with Democrats perhaps poised to retake the presidency, we are experiencing a new, predictable wave of executive action enthusiasm among the liberals and the left. Perhaps the best example, both in terms of quality and typicality of sentiment, is the recent American Prospect series, quote, The Day One Agenda, unquote. In a series of well researched and well argued articles, contributors to the series set out an ambitious set of policy reforms, ranging from student debt cancellation to carbon reduction to postal banking, all of which could be brought about, the contributors insist, through the exercise of existing statutory authority. In other words, even if Congress remains inert, a progressive president could, the series argues, could bring about much, if not all, of the change that we need. I don't know who claimed all. I doubt that anybody thinks that the president alone could bring about all of the change that we need. Certainly not when it comes to the Green New Deal. The inclination for projects like this makes sense, says Ryan. The nation and the world faces enormous problems Congress is unwilling or unable to solve. Surely some other state actor must be able to pick up the slack. The problem is they can't, or at least not anywhere near the necessary scale. Whereas still, by pretending otherwise, we're putting off the hard work of fixing our dysfunctional Congress, which is to say, our broken democracy. To see the limits of executive action, one must first understand the strategy. Take one of the more intriguing proposals in the, quote, Day One Agenda, unquote, that a president should, acting through his or her subordinates, cancel nearly all student debt. First advanced by Luke Hareen of Yale Law School. The argument is, very roughly, that the Secretary of Education can be authorized under the Higher Education Act to compromise, waive, or release claims against student debtors. As Hareen argues, the Secretary's grant of discretion is not textually constrained. There are, for example, no specific reasons the Secretary must invoke before waiving or releasing a claim. Okay, in other words, the Secretary can waive or release a claim even if someone doesn't pay their debt or is not making payments on their debt. Absent such a specific constraint, Hareen continues, the executive branch enjoys nearly unreviewable discretion in determining which claims to decline to pursue under current Supreme Court precedent. Taken together, Hareen concludes, these observations support a reading of the Secretary's authority that would permit him or her to, quote, waive, unquote, or release, quote, or, quote, release, unquote, all claims against the student debtors over which the Secretary has enforcement authority, which is to say, all student loans directly issued by the federal government. which according to Hareen is 95% of outstanding loans. Hareen's argument is both extremely simple and extremely clever. He identifies what is on its face a very broad grant of discretion to an executive branch official, then urges that official to exercise that authority in a surprising but straightforward way. As Serene concedes, a grant of authority to settle student debts might seem to be mundane at first pass, intended to permit the secretary to waive or release claims against individual debtors in cases where enforcement would be futile or especially harsh. But as Hareen correctly points out, nothing in the statute explicitly requires the secretary to make such decisions on an individualized or case by case basis. To the contrary, all the statute says is that the secretary may waive or release student debt claims. And if we take the statute's language seriously, as the Supreme Court has for years insisted we must, then the fairest reading of the Higher Education Act is that the secretary may waive or release student debt claims, all of them, for whatever non-discriminatory reason. Perrine's proposal is an instance of a general strategy used often since the later Obama years. Strategy is to identify broadly phrased grants of authority to the executive branch within existing statutes, and then to attempt to use that seemingly broad authority to address problems or concerns not necessarily contemplated at the time those statutes were enacted. In this respect, Hareen's proposal and others like it are very much of a piece with the contemporary approach to statutory interpretation, advocated most prominently by conservative judges like Justice Scalia, Justice Thomas, according to which the content of the law is a function of what the statutory language specifically says, as opposed to the general goal or problem Congress might have had in mind when enacting that when enacting that language. And I'll make a comment here, which is to say, that is one doctrine shared by Scalia and by Thomas, but a second doctrine that's shared by Scalia and by Thomas was the doctrine of the unitary executive, which involves a very strong interpretation, of law in favor of the executive, in favor of interpretations that would rule very favorably on broad authority to address certain problems or concerns when Congress grants that authority to the executive in the form of statutory content. In other words, the language, the text, of the statute. So it's not simply the idea that until recently, the judiciary just when it was interpreted by conservatives who fixed on the language, that the intent of Congress was not as important for these justices as the actual content of the language. But not only was that doctrine favored by them, but also a second doctrine that interpretations of the power of the executive should tend towards the idea of a unitary form of the such that the executive functions of the federal government are to be interpreted as falling within the purview of the presidency as the supervisor of all of activities that can be classified as executive activities under the Constitution. going on with the article, with Ryan's article. It may seem that Hareen's argument should therefore be a clear winner. The problem, however, is that courts increasingly seem not to be taking that language-centric approach in precisely the context where they would need to in order to make this type of creative executive action actually work. Well, maybe courts in general may not be taking that language, but the question is whether Justice Thomas is not uh, still taking a language centric approach, and whether Neil Gorsuch, okay, and also Kavanaugh, who in general were Scalia followers, would not be taking a pronounced approach towards interpreting the Constitution in a language-centric way, and according to the doctrine of the unitary, the unitary executive. That's the question. Anyway, Dorfler goes on. Okay, the difficulty for creative arguments like Hareen's is that many courts, including the Supreme Court, have become skeptical of creativity as such, sometimes referred to as the anti-novelty doctrine, quote unquote. Many contemporary judges, especially conservative ones, regard claims of authority as questionable unless someone has claimed that authority before. The basic idea is that if the law has been around for some time, a claim today to have discovered some new authority in that law is obviously suspect. In other words, surely if the law really provided that authority, someone would have noticed and claimed it already. Courts invoke the anti-novelty doctrine most explicitly in constitutional cases. In Free Enterprise Fund versus Public Company Accounting Public Company Accounting Oversight Board, for example, Chief Justice Roberts concluded that Congress's mechanism for removing members of an accounting oversight board unduly constrained the president's authority to manage the administrative state. The Chief Justice reasoned in part that this novel arrangement tellingly lacked historical precedent. This suspicion of novelty carries over to statutory cases, okay, as well. But again, this example is not an unambiguous example because it sets the novelty doctrine. It sets the novelty doctrine or the anti-novelty doctrine in the service of the unitary executive power. In other words, Roberts concluded that the novel claim that Congress had the authority to remove the members of an accounting oversight board unduly constrained the president's authority. So the Chief Justice here was upholding the unitary executive doctrine, okay, as well as the anti-novelty doctrine. So the question is, what happens when those two doctrines come into conflict? Here, when the two doctrines came into conflict, with the novelty, the anti-novelty doctrine, I'm sorry, here they did not come into conflict. The anti-novelty doctrine was supporting the interpretation, okay, that was a unitary executive interpretation. Okay. But there may be a case which could easily come up where the anti-novelty doctrine would come into conflict with the unitary executive interpretation. Such a case actually exists in terms of the claim that the chief executive has the right to order the mint to produce a high value platinum coin. For example, in the $100 trillion range, then what one could conceive a case where people would come in and claim under the anti-novelty doctrine that no executive has ever claimed this authority before, even though the law that's the basis for the authority has content that certainly implies that, but that was passed in by 96, okay, and that authority was never claimed by any previous president. So that, let's say such a case were to occur in 2021, that would be 25 years past the actual passage of the law, and no president had claimed such an authority. But if a president was to do so in 2021, then the anti-novelty doctrine could be brought against such an authority on the part of the president in court. But at the same time, okay, the unitary executive authority, in other words, that particular doctrine, okay, the unitary executive would argue in favor of the president having the authority to mint the coin. So there, the conservatives would be in a quandary, and people who were strongly in favor of a unitary executive interpretation of the Constitution, specifically Kavanaugh, Gorsuch, most probably Sam Alito, and Justice Thomas, would probably all be reluctant, okay, to deny, to use the anti-novelty interpretation to overturn, okay, a unitary executive interpretation. At least they would have to think about that. And on the other side, it would also be something of a quandary, probably, for the people who are considered the liberal justices of the Supreme Court, because of a Democratic president, what to claim such an authority in order to get past a debt ceiling crisis or something like that. They would, on political grounds, be inclined, I think, to support a Democratic president in this respect, but they might not like content justification, okay, or a unitary executive justification much. So that's going to be an interesting situation in that case. Anyway, Dorfler goes on. In FDA versus Brown and Williamson Tobacco Corp., the FDA claimed authority to regulate tobacco products on the grounds that the Federal Food, Drug, and Cosmetic Act empowered it to regulate drugs and also delivery devices for drugs, with drug, quote unquote, defined capriciously to include, quote, articles other than food intended to affect the structure or function of the body, unquote. Reasoning, okay, that nicotine was plainly, quote, intended to affect the function of the body, unquote, the FDA had concluded that cigarettes and other tobacco products constituted, quote, drug delivery devices, unquote. Notwithstanding this straightforward interpretative argument, Supreme Court held 5-4 that the FDA lacked the authority it claimed. According to the conservative majority, the FDA's claim was not only mistaken but implausible, because the Federal Food, Drug, and Cosmetic Act had been on the books since 1938. But only decades later, in 1996, which, by the way, would be almost 60 years later, in that case, was the FDA claiming the authority that it was claiming. So there's a case where the anti-novelty doctrine was in conflict with the unitary, uh, with the doctrine, okay, of the unitary executive. In that case, the court was ruling for, okay, the anti-novelty doctrine, but that was but nearly a 60-year period, okay, a 58-year period, whereas in the platinum coin case it would be only a 25-year period. So I don't know how things would go in terms of difference there, but anyway, FDA versus Brown and Williamson is especially relevant given its underlying political dynamic. In 1996, a divided government made the enactment of comprehensive tobacco legislation impossible. Rather than be frustrated by an uncooperative Congress, however, President Clinton urged the FDA to assert jurisdiction over tobacco products, pursuant to a novel but entirely plausible reading of its existing statutory authority. If anything, it was difficult not to read the text of the statute as consistent with the FDA's claim. Who could argue that nicotine was not a drug, quote unquote? The answer, it turned out, was a conservative majority of the Supreme Court. To be clear, the anti-novelty doctrine is a bad interpretive doctrine, as law professor Leah Lippman has argued. Leah Littman, has argued. There are all kinds of reasons government actors may not have previously claimed authority beyond the belief that they lacked it. Demanding procedural requirements and limited limited okay and but and also limited limited well, you can probably read it for yourself. Okay, it's legislative, executive resources. Keeps government actors from doing all sorts of things they might otherwise do. Similarly, political pressures stop federal officials every day from enacting policies they are legally authorized to enact. The FDA's failure to assert jurisdiction over tobacco products prior to 1996, for example, was surely attributable to the political clout of the tobacco industry, at least in part. Why then does the anti-novelty doctrine persist despite these straightforward kinds of objections? Most obviously and most cynically, anti-novelty is a small c conservative interpretive principle that appeals to small c conservative judges. The anti-novelty doctrine is quite literally an interpretive presumption against significant change. For judges opposed on normative grounds to significant change, a doctrine that rationalizes and codifies that attitude is going to make a great deal of sense. Less obviously and more charitably, adherence to the anti-novelty doctrine reflects the belief that major policy changes ought to be accompanied by changes to the relevant written law. With the decision to regulate tobacco, for example, the clear message of FDA versus Brown and Williamson was that such a policy shift should be made through new legislation, as it ultimately was, though not until 2009. This sort of insistence upon congressional decision making expresses a commitment to what lawyers call non delegation, quote unquote. The idea, put simply, is that the Constitution assigns to Congress and not the president the authority to enact new laws. That for Congress to grant to the president sweeping policymaking authority would be inconsistent with that constitutional assignment. Courts have famously been unwilling to declare such grants of authority constitutionally invalid. At the same time, they've been more than willing to read such grants in implausibly cramped ways, as in FDWA versus Brown v. Williamson, as a way of limiting delegation indirectly. Whatever one thinks about this principle, anti-novelty is with us for now, with Chief Justice Roberts and Justice Kavanaugh as the doctrine's strongest supporters. Supreme Court is exceedingly likely to invalidate creative executive action by a Democratic administration on anti-novelty grounds. Absent changes to the court's composition, then, a bold day one agenda seems doomed from the start. And considering this concern, uh, and considering this concern, oh, the political scientist Scott Lemieux writes in his contribution to the series that the prospect of judicial hostility provides reason for, quote, concern but not defeatism, unquote. He argues that although bad legal reasoning will prevail for issues that are a top priority for elite Republicans, unquote, with, quote, but lower order issues, better legal arguments at least stand a chance. So Lemieux's distinction between more and less important cases is fair. The Supreme Court only hears some 80-some cases per year, which means that low visibility executive action would likely evade review by the Supreme Court. Yet, Scott's defense reveals a mismatch between the implicit promise of the day one agenda and the reality. By his own assessment, taking aggressive by his own assessment, aggressive executive actions by an incoming Democratic president would likely result in modest but valuable policy reforms, surviving or escaping, by changes by the judiciary. But at the same time, larger, more sweeping changes are reliably being struck down by an unsympathetic Supreme Court. On the one hand, then, the, quote, day one agenda, unquote, is a valuable resource outlining a strategy worth pursuing. Because gains that are modest are, after all, gains. On the other hand, to the extent the day one agenda was meant, as it seemingly was, to assure us that an obstructionist Congress would not be that big of an obstacle, that a savvy president would, on his or her own, be able to achieve some major reforms, we should be skeptical. The American prospect has been fairly open in its advocacy for Senator Warren in the 2020 primary. There's nothing wrong with that sort of advocacy. Still, reading the day one agenda in this context helps to situate it in the broader Sanders as opposed to Warren debate. One recurring argument in that debate has been that Warren has a much more detailed understanding of the president's statutory authority than Sanders, and so would be more capable of carrying out an ambitious executive agenda. Setting aside the plausibility of that argument, surely President Sanders, just like a President Warren, would rely upon legal staff to make such judgments. And while I'm sure that's true, I'm also sure, that President Sanders has a much longer history of studying the presidency than Senator Warren does, and that he's also studied very carefully the history of the New Deal, and therefore is something of a student of the powers of the presidency in terms of using, in terms of what can ambitious president would be able to do on his own authority. But anyway, going on with the article, Day One Agenda can be read as an effort to highlight Warren's comparative advantage in getting things done. That's an interesting point. And and when it first was written, okay, on the first of this month, it seems more plausible than now, since the fading of Warren's hopes. I don't mean to counter out completely, but she's certainly been falling in the polls substantially over the last month. Anyway, whatever the motivation, the article says, the Day One Agenda reflects a tremendous and pervasive optimism about clever solutions among Warren's natural support base. The highly credentialed are unsurprisingly predisposed to think that bad situations can be managed or avoided through informed or creative types of reasoning. So it should also be unsurprising that highly educated voters have been drawn to an impressively credentialed the former legal academic who promises to solve this nation's problems through policy and legal expertise. The problem, of course, is that we've tried this before. President Obama himself, an impressively credentialed former legal academic, had only some modest success in his attempts to make policy via executive action. For example, both his more ambitious deferred action immigration program and his Clean Power Plan were blocked or delayed by court challenges. That experience should give us reason to doubt that a broken Congress really can be cleverly sidestepped. Okay, while I agree with that comment, I have to point out that Senator Warren is more impressively credentialed than Senator Obama was when he ran for the presidency. Okay, another one. The first had been a student, okay, at Harvard, and was a lawyer, and taught some constitutional law as an adjunct professor. Okay, but that is not as impressively credentialed as a Harvard law professor for decades. Okay, which is what Warren was. So I'd argue that at if you compare the two when they first ran for president, that Warren had a longer career in studying the law, okay, than Obama did. But put that aside, I think the point, okay, is still a good one, that uh, the experience, okay, of Obama in trying to get things done without actually relying on the legislature was very, very mixed. Okay, of course, he only tried serious action, okay, in this respect in his final year because he finally realized, okay, at that time that he had a pen and that he had a phone. But anyway, going on. So, what to do? It seems like the only real answer is to fix our broken Congress. And in contrast to Warren, Sanders does have a plan for that, albeit not an especially clever one. Sanders' plan is based on political hard work and brute force, building and sustaining a mass movement to force government actors to enact ambitious policies. We can see a microcosm of such a movement in the shape of the Chicago Teachers Union, which just secured important concessions from public officials through a popular strike. We see it in the recent mass demonstrations on climate. We see it abroad in places like Santiago, Beirut, and Hong Kong. Whether that sort of mass movement can be broadened and sustained in the United States over the period of the presidency and further than that remains to be seen. But while Sanders' strategy may not be easy, it at least addresses the actual problem. Okay, moreover, it seems to be our only hope. So I'll hold off on further comments on that because I want to consider further comments in light of the reply to it by Dave Dayen, which occurred on December 16th of 2019, which appeared in the American Prospect, which was the magazine that originally published the Day One Agenda series, and which is also the magazine, that Dave Dayen is the editor of. So, Dave calls this "Make Progress on All Fronts," a response to Jacobin, and that's where the title of this live stream comes from. I'll put this in clearly so you can see it better. One of the stranger features of contemporary political writing is what I've called the, quote, one true path, quote, fallacy, the notion that rather than making progress on all fronts where possible, one and only one course must guide all actions. This did certainly be kind of an implication of the Jacobin article, I have to say. In other words, its objections to what Dave was saying seemed to be that the president by himself can't really do much if he relies only on the power of the presidency. But I don't think Dave Dayen and the other writers were assuming that that's all the president would do. In other words, the president, while trying to strengthen things with executive orders and executive authority in all sorts of ways and bombarding the courts, with various things under cover, of executive authority claims, would at the same time be using mass movement to back up what he was doing, and at the same time as well by using political campaigns to back up what he was doing, and also at the same time trying to get through Congress what he was doing. All those things would be going on at the same time, and also the path of trying to replace as many of the conservative federal justices as possible in a variety of ways. I don't know what Bernie's going to do, but it's pretty clear that he knows about a lot of different ways to try to change the situation of conservative interpretations by the judiciary. In fact, in one of the town halls he had today, I think, in the one with, I thought it was Larry Lessig, and Zephyr Teachout, they were starting to put forward questions about the Granny D strategy for trying to get past the Supreme Court. Sanders indicated that he knew about that. Now, the Granny D strategy involves the idea that Article 3, Section 2 of the Constitution could be used to bypass the judiciary in certain ways, when it needed to be bypassed. So that is one way for the legislature, if Democrats had control, of the legislature, to get by a judiciary that was hostile. Now, that can't, of course, be done by simply using only executive authority, but I was impressed that Bernie had heard about Article 3, Section 2, evidently somewhere. Now I'm reading this into his reply during the town hall. He didn't say anything directly about Article 3, Section 2, but the Granny D strategy, so called, involves applying Article 3, Section 2, so that's why I inferred that. Anyway, to go on with the article, uh, so Dave is objecting to the idea that a one and only one course should guide all actions. Okay, he goes on to say, attendant with this is the concept that straying from that one true path will irreparably harm the cause more than it will help. And he says this is ahistorical. The New Deal was a time of bold experimentation where FDR pursued actions that were of a unilateral nature. He collaborated with Congress and also made veiled threats at a judiciary that had curtailed his agenda. He tried unsuccessfully picking off members of Congress who voted against his preferences, and he responded to grassroots activists demanding old age insurance. He but pursued immediate and emergency actions like the bank holiday and long-lasting legislative ones like the Securities Exchange Act of 1934. There was no self-censorship, no fear that executive authority would harm the legislative agenda or the fight in the streets. There was a depression on, and progress was progress. Okay, so I want to underline that. I very strongly agree with that, and I point out that let's say what we might expect will happen in 2020, that the Democrats will hold on to the House and may even increase their margin in the House. Because I expect that if Bernie is the nominee and he wins, it's going to be a wave election, in favor of the Democrats. But let's say the wave, it's not strong enough to win over the Senate. So the Republicans still have a small margin of 1 or 2 votes, in the Senate. Now, that doesn't mean that Bernie will be stymied in passing all his legislation in 2021. Because, don't forget, the movement will still be there and will be even stronger based on the victory in 2020. And he's not going to defang the movement. He's going to encourage its continued growth, and strength. And the direct pressure on Congress, Democrats and Republicans alike, to pass his Green New Deal agenda and to pass a Medicare for All bill as soon as possible, by any means possible, and to also have democracy reform as soon as possible, by any means possible. Now, it may have been fairly easy for a Republican majority of 6 votes in the Senate to resist that kind of pressure up until now, especially with the aid of a House that was hostile to the kinds of changes and reforms that Bernie Sanders is likely to see. But if we head into 2021 with Sanders in the presidency, with a new speaker in the House more friendly to the agenda of the president, and with only a 1 or 2 vote majority from the Republicans, there's no way the Republicans are going to be able to resist the pressure from Sanders and from the movement to, first of all, support Sanders' executive orders, and second, to pass some of the legislation to give him a heads up, because what's going to happen is those things that are not legislated by Congress, like if there's no Medicare for All bill, And if there's no Green New Deal passed in 2000, okay, in 21, then Bernie's going to be running on that in 2000, okay, in 22. And this time, there'll be an active progressive movement looking to pick off people in primaries. That was not something Roosevelt had as a tool of his in 1933, 1934, 1935. If he received any opposition from conservative Democrats during those particular years, he could threaten to pick them off in some way. But it was always a case of a Democrat, the incumbent, that was running against, okay, a Republican. And if that incumbent was a conservative Democrat, it was hard for Roosevelt to get to him. But for Sanders in 1922, approaching the congressional elections of 1932, he's going to have a robust movement in the primaries trying to get rid of any Democrats that are still opposing his program in 2000, okay, in 22, and running against any Republicans in the Senate that are firmly against his program and still trying to block it. This is not going to be like it was, okay, with Obama in 2009 and 2010 when Obama defanged the Obama for America movement because he didn't want them bothering him when he was the president. That's not Bernie's way. He's not going to do that. He's going to do the opposite. Congress won't have seen anything like it, ever. Ever. I mean, the Senate is going to be on the voting block if it doesn't turn Democratic in 2020, election 2020. It's going to be on the voting block in 2022. It's going to be almost a major issue in 2022 because it'll be blocking very much of his program if we still have a majority leader, Mitch McConnell. I'm assuming that there's a good chance we may still have him. But that's going to be quite a fight, and you can be pretty sure who's going to win that one in 2022. It's going to be Bernie. You can bet your bottom dollar on that. Anyway, going further. That's what puzzles me about Dorfler's essay in Jacobin, attacking a day one agenda as a pointless exercise that will freeze our broken democracy in amber. Not only does this misread the purpose of the day one agenda, it contradicts the belief in a strong central government consistently advanced by the likes of a Jacobin and the man it wants to see become the president. I don't know where the idea came from that progress is a hindrance to progress, but it's incorrect by definition. Dorfler's article, Executive Orders and Smart Lawyers Won't Save Us. Just as an aside, nothing in our series is an executive order. They're all implementations of existing statutes. Puts forward two obstacles to the day one agenda. The first is so obvious we put it in the series. What if the courts invalidate a president executing existing laws they don't like? Using an example, the proposition that the president can direct the Secretary of Education to waive or release all publicly held student debt. Dorfler argues that conservative justices will simply use the anti-novelty doctrine to invalidate attempted interpretations of legislative statutes that have not been used before. Not every proposal in the day one agenda is novel in this form. Limiting power plant emissions and other toxins were in place before Trump came into office. A few still are. The bank regulators have endlessly tweaked regulations more or less stringently and can do so again. Even George W. Bush, as Health and Human Services Secretary, threatened to take away drug patents from pharmaceutical manufacturers. Dorfler managed to pick one item in the agenda that hasn't been previously tried to make the argument the whole agenda will fail because it hasn't been previously tried. And here again, I'm going to bring up the platinum coin seigniorage case. Right now, platinum coin seigniorage exists. It exists. Platinum coins are manufactured by the federal government right now under the orders of the Secretary of the Treasury, okay, and the Director of the Mint. Now, they're not these high value platinum coins. They're basically collector's items that are sold for something like, well, I don't know what they're sold for, maybe $3,300, $3,500 or something like that. But there's some coin seigniorage in them. And the federal government is now earning that particular coin seigniorage. So the difference between that coin seigniorage and the coin seigniorage that would be inherent in a $1 trillion coin, okay, or in a $100 trillion coin, there's no difference in kind there. It's a difference in amount. So the executive would be able to go into court in that situation, okay, essentially making the claim, look, coin seigniorage has been an established use of that law. Both coin seigniorage and platinum coin seigniorage has been an established authority of the executive branch since that law was passed in 1996. The only difference here is that these are the first coins that were denominated in the $1 trillion range, or the $100 trillion range, or the $50 trillion range, or whatever the quantity is that the secretary chooses to mint. So, the point here is, if the Supreme Court says that to manufacture a platinum coin with a $3,500 face value is perfectly constitutional, or say a $1,000 face value is perfectly constitutional, but a $1 trillion face value, okay, is not constitutional. Why? Not because of the language of the law. Language of the law sets the face value of the coin up to the discretion of the secretary. The language of the law provides no basis for distinguishing at all between a $1,000 platinum coin and a $1 trillion platinum coin, or a $1 trillion platinum coin and a $100 trillion platinum coin. If the court were to decide one is constitutional, okay, and another was not, it would be on very, very thin ice and be obviously deciding the case rather than on legal grounds, and deciding the case on the basis of its own political interpretation of the intent of Congress. And what would the political interpretation be about? It would be about the idea that Congress did not intend to give the executive branch the power to bypass the debt ceiling law. That's what the political judgment, okay, would be about. And it would be a very controversial political judgment. And if the president were to mint the very high value platinum coin in order to prevent a default, okay, of the federal government, then the Supreme Court would be facing horrible consequences if it would deny the president the authority under that law to mint that very high value platinum coin. And not only horrible consequences in that sense, but horrible consequences in the sense that it would be a precedent set by the court to limit the authority of the executive on wholly arbitrary grounds, when these conservative justices have been the defenders of the unitary executive interpretation. So in this instance, I think they'd be very, very unlikely to use the anti-novelty approach to overturn the platinum coin. But anyway, I wanted to consider that here too. So, going on. But nevertheless, we are aware of the concern of judicial meddling of this type. We're so aware that Scott Lemieux addressed it directly in the series, calling it the elephant in the mouse hole doctrine. Congress won't hide elephants in mouse holes, the story goes. It's also worth pointing out that Dorfler admits this is a bad interpretive doctrine, quote unquote, used primarily by conservative jurists to reject actions they disfavor. I don't know one world exists where the same Supreme Court judges would reject executions of existing statutes but wave through implementation of newly passed statutes like the Green New Deal, okay, or Medicare for All. The logical extension of Dorfler's argument is a recipe for nihilism. It is. It is. Now, that doesn't mean I think that Kavanaugh is not a nihilist. He may well be. He's a horrible person, so he may well be. Anyway, here we go. This brings us to Dorfler's second contention about the Day One agenda, that it's a distraction from the hard work of fixing Congress. In doing so, the Day One agenda argues for a Warren presidency. Dorfler believes, with its focus on clever executive maneuvering rather than the block and tackle, okay, of revolutionary politics. Okay. Okay. Now that's not Dave Dayen making this contention. He's saying that this is a contention, okay, of Dorfler's. That Dorfler is arguing that the Day One agenda is somehow correlated to a Warren presidency, or that those who wrote about that felt that way. So the article then goes on. Jacobin has been quite aggressively in the tank for Bernie Sanders, and there's nothing wrong with such advocacy. But by deciding to see everything through the lens of the 2020 primary, they've now decided to attack something Bernie explicitly supports. Because, see, we asked every presidential candidate if they would agree to adopt a Day One agenda. And Sanders agreed to do nearly all of it, as you can read if you scroll down the page of every article in the series. Sanders is enough of a legislative insider to understand that making progress through existing statutes in no way prevents the work of building a mass movement and forcing the political system to respond. See? Sanders spent most of his career in the House passing small bore roll call amendments that helped people in his state and throughout the country. He managed to do that and argue for a new politics simultaneously. Yeah, Bernie was known as the Amendment King. Of course, Jacobin knows this. They published what could be seen as a miniature version of the Day One agenda in February, which noted how, quote, executive orders are powerful tools for the president, unquote, and specifically pointed out that while ultimately only a mass movement can bring the necessary change, quote, building that movement is not exclusive with aggressive executive action, okay, or mutually exclusive with the with aggressive executive action, unquote. As a side note, the Jacobin story on executive action includes a handful of components of the Day One agenda, including postal banking, climate regulations, and canceling student debt, the very idea that Dorfler deems impossible due to judicial intransigence. I put together the Day One agenda project because of the despair that future Democratic presidents would serve as mere placeholders thanks to legislative obstruction. That diminishes the significant, obvious power presidents hold. You need only watch the presidency of Donald Trump with its scant legislative accomplishments, but major transformations in areas like immigration and federal benefits to understand that. Just because President Obama resisted using executive authority, and even when he did, aimed lower than he could have, doesn't mean the Democrats should be conditioned into thinking it is impossible. Of course, executive action represents only one step in a broad program, ending our legislative dysfunction, including abolishing the filibuster. If it were up to me, abolishing the Senate or turning it into a domestic version of the House of Lords is obviously paramount, But there's no reason not to bring tangible benefits to the public while that work takes place. In fact, one can assist the other. A Congress being circumvented will be more inclined to intervene and put their stamp on any changes. And once these are in place, the Supreme Court will likely be cautious of taking those benefits away. Witness John Roberts' numerous punts on the Affordable Care Act. Most important, the chief executive showing the commitment to do big things in service of the people will raise hopes among the people that their voice finally matters. It will help build power in that mass movement, especially if the ideas come from the movement, as the idea of canceling student debt did. And I point out here, as well, that doing all this through the movement, if Sanders does all this through the movements and is successful, it is going to put to shame the presidency of Obama, not just the presidency of Trump. It's going to point out how ineffective and what a poor president Obama was. What a fantastic chance he missed in 2009 and 2010 with his support for the establishment and for the donors and his protection of them from the movement that he had himself created and that he defanged when he came into office. I will never forgive him for that. Why this promise should be thrown away based on the incorrect assumption that executive power is a mere Warren campaign talking point is a bad faith reading that makes no sense, especially as Sanders believes in the power of executive action too. Too many writers at Jacobin have gone so far around the bend that they'll deny progress to make an electoral point. No, I won't say that. I don't know the writers at Jacobin sufficiently well to have made the judgment they've gone around the bend. But this one writer, I think, but Dorfler, certainly did go around the bend. That the progress they're denying is part of their preferred candidate's platform makes it all the more bizarre. Quote, the Day One agenda is a valuable resource outlining a strategy worth pursuing, unquote. Dorfler writes in one of his more charitable moments, we agree, says Dave Dayen. And I agree too, and I agree that the multifaceted, multi-method approach outlined by Dave Dayen here is Sanders' approach. If anyone has a single method approach comparing these two, it is Warren. She might like to rely on smart and wonky kinds of administrative moves if she were elected to the presidency, because she could make those moves and make some of the pressure off, and relieve herself of the obligation to pass laws that are meaningful in the long term for people, but which oppose the interests of the donors. She might make temporary changes involving administrative interpretations as placeholders for what she promises to do in the long run, while avoiding using movements and using aggressive election campaigns to put pressure on the Congress to do the will of the president, the progressive president, because perhaps she wouldn't be that but she might not be the progressive president that we want to see. On the other hand, if Bernie becomes the president, you can be sure all the tools on the table will eventually be used to pass that platform that he considers a necessity. He will be very like Franklin Delano Roosevelt in that respect. He will throw everything up against the wall that can possibly work to create the Green New Deal and the just transition to it and the democratic advanced society that we so badly need to make America great. And I won't add the final word to that particular slogan because I just don't believe in the final word. This would be the first time if it happens. Okay. So that's my presentation for tonight. Okay. I hope you liked it. I will consider your comments at length. But first, please share and like this video, and please share, like, and subscribe the YouTube video when that comes up roughly 20 minutes after I finish this one. And please become a patron at www.patreon.com/Joe underscore Firestone. I really need more continuing financial support to do this particular video. I do not have the kinds of multiple sources that other live streamers have because I'm not at that level with respect to YouTube yet. I need many more subscribers, okay, on YouTube. So for now, my sole way of obtaining small levels of support is through the Patreon account. So please visit Patreon for me and help me out if you can. Only if you can. So let me go to your comments now and see what you have to say. I hope you've been sharing. Russ says, I'll call it a night. See you again soon. Thanks for coming, Russ. And Cora says, I hear a slight echo. I'll turn that down a bit. I hope I've limited the echo somewhat. Rich Serber has joined. Steve Wolfbrand joined. Randy Hedgebeth. Hi, Randy. Sam Woods is here. Hi, Sam. Steve Day has joined. Hi, Steve. How are you? Cheyenne's here, and she says, hi, Kay. And Kay says, I watched 3 town halls by Bernie today, and one was all about voting rights and democracy. Very good. No other candidates do those town halls like he does. I know. He's great at those town halls, isn't he? Because of the New England town hall background, okay, and experience. Yeah, Bernie's like a professor who never became a professor, but one who talks our language. Okay, and Beverly Couch is joined, and Steve Day says, former student loan holders who paid off would like to have some reparations. I understand the need for reparations. Okay, I'm also for that, but let's get the forgiveness of student debt first, because that's the first problem, and also free college. Okay? And then I think once Bernie has social credit that's built up through that, and as well through the Green New Deal, okay, and Medicare for all, once he is past that, I think then he'll have enough of public opinion behind him that if he thinks it's worthwhile to actually do the reparations, then he'll do reparations. Kay says, when I was young, college was cheap. Yeah, when I was young, it was cheap too, even private college. Kay says, wish I would have gone to college instead of saving my ex from a draft. But laugh out loud. The biggest mistake I made in my life. Steve Day says, but what are you missing, really? A real life where I can support myself and not have to try to exist on $600 a month by low-wage worker Social Security. Steve says, look into federal jobs guarantee, okay, proposed in the Green New Deal. Others are with you. I think Kay knows about the federal job guarantee. And Russ Gorman is joined, and Kay says, I'm old and have a bad back from driving trucks 15 years or so. Sure, I can physically do much, but I would love to help in some way. I actually miss working. I can't even afford to have a car anymore. But Kay, the federal job guarantee is going to provide jobs for people who, in some circumstances, might be considered to be disabled. But I think there will be jobs that are not physically demanding, where one can work out of their homes. I think that's going to be a feature of the job guarantee. And if it's not a feature of the job guarantee in your particular area, well, it will be in some local areas, okay, around the country. Okay, I understand you have a trailer. Okay, I guess you don't have a car, but you could probably rent a truck and tow your trailer to those areas where they have such jobs available. And you'll be able to find out from a national registry where such jobs exist. Steve points out these FJG jobs be described and administered by communities. You would describe what you can and would enjoy working and be matched with community needs on your level. And even if that's not there in the registry, there will be opportunities to propose jobs that will fit you and to get grants for new social enterprises that would contain those particular jobs. You could join with others and write up the proposals for the grants. And if they meet the local community needs, the federal government will fund the workers for those social enterprises. And some of the expenses too, though the expenses would go to the local communities, but then for your expenses, you could submit vouchers to them to get those expenses for those businesses. Anyway, Kay says, Bernie does back a good Social Security expansion, though, so hopefully that will help me have a real life again and maybe afford a car so I can help in some way. My lead hubby and I used to do house building and rehab, so I have the knowledge. Just can't do what I used to do physically anymore. And Steve Day says, yes, expansion of Social Security programs in lieu of Yangubi. Yangubi. I'm so desperate I'll take either, although Yang is going nowhere fast, and I love Bernie bunches. Okay, and Andrew Nargolwala has joined. Hi, Andrew. And Kay says, Bernie can figure out how to get things done. And Kay says, Obama's a corporate dem, not at all impressed with him or his presidency. And Kay says, hi, Dolores. Kay says, living here in the toxic waste dump of Ohio makes me laugh when people complain about smoking on SMH. The shit they put in the air and our water here every day and all day is the problem. Cheyenne says, I'm concerned about some of Bernie's staff. And surrogates. I have a list of people over five in executive. And Cheyenne says, executive orders. And Cheyenne says, by Shahid Buttar to replace Nancy Pelosi. Well, I certainly want her replaced as the congressperson from that district because then she will not be speaker again. But when Shahid comes in, he'll be coming in as a freshman congressperson, and he will not be the new speaker. Uh, yes, I endorse the idea of donating to Shahid Buttar and sending Pelosi packing. But I think the new speaker then would likely be someone like maybe Barbara Lee or Pramila Jayapal. I think would be a good candidate, or maybe Ro Khanna. And Kay says, yes, I'd love to see that. Corporate them gone. Lana has joined, and Russ says, I've got to call it a night. See you again soon. Thanks, Russ, again. Dolores says, thank you and good night. Susan says, good night. Kay says, Jenk is running for office in California, too, and is running a non-corporate but donations agenda. I'd love to see him cause some hassles in Congress. I'll laugh out loud. Okay, donate if you can. Yes, I certainly agree that Jenk is worth supporting. It would be wonderful to see him in Congress. It would be wonderful to see his very strong voice supporting the movement in Congress. Okay, I'm very much in support, okay, of Jank. The only thing I have not liked about him, okay, in the past, is that he's been so strongly in back of the party, the party, the party. Okay, but since we're all running, okay, since the agenda is to change the party, okay, and to gain control of the party, it seems very reasonable at this point for us to have Cenk in the Congress and strongly support him. He's going to be a big help to us if he gets in. He's certainly a monstrous improvement over Katie Hill, a monstrous improvement. He is going to be a ringing voice to join with all the other Justice Democrats. Okay, how are we doing? Are there any other comments or questions or claims? Please share. I noticed that there were very few shares tonight. Please help me with the shares as much as you can. Thank you very much. I'll give you a moment. If you have any more comments or questions, and if not, I'll be saying good night. Kay says, John can yell with the best of them. Laugh out loud. I share, Joe. Thank you for sharing, Kay. Cora asks if there have been any new impeachment developments, Kay, of late. Uh, the one that seems to be gaining most attention is, well, there seem to be some new issues that are coming to light, but it's hard to see when you. It's hard to say whether any of them are really consequential or just new things for the people who want to impeach him over the Ukraine issue. They're always making statements like, "Oh, we've got him now. We've got him now. This is going to get him." Okay, and then it turns out to be a flash in the pan. Okay, of some kind. But there has been one particular development, and that is some talk from Lisa Murkowski, okay, about her having doubts about proceeding with the trial in the Senate without stepping back and calling witnesses and going in without a preconceived notion of how this is going to work out. And she seems to be genuinely disturbed by the idea that the Senate Majority Leader will coordinate with the White House on this, because of course, technically, every senator is supposed to be a juror in this trial. And the idea of the jurors coordinating with a defendant. I mean, that's what we call a rigged trial, right? A rigged trial. So Lisa Murkowski is starting to stand up a bit for the institutional integrity of the Senate. But I haven't noticed anybody joining her yet. I haven't seen her joined by Mitt yet. I haven't seen her joined by Martha McSally yet. I haven't seen her joined by some other people, by Susan Collins yet. So I would say there's not much movement on impeachment yet. There are some poll numbers that suggest, though, that the polls have again turned towards the Democrats on this and have turned away from Trump. Those are the latest results of some of the polling. It now looks like a majority of Americans, small majority, but a majority of Americans are in favor of the removal of Trump from office. KS says, thank you for being here, Joe. Always great to talk with you and other like-minded folks. Well, thank you for coming, Kay. It was very good to have you here tonight. Thanks for sharing as well. Any more comments at this point? I'll see if I can get my head above the horizon here. I see that what you've been seeing for a good part of this time is part of my nose as I bend over the comments. I'm trying to read them rather than staring at the monitor I have towards the side where they're easy to read. I'm finding it hard to break the habit of staring at the small screen instead of my large screen here. Anyway, thank you all for coming. Kay says she's got to go to bed. And love you all. Take care of yourself, Kay. I should be back on Monday night at around about 9 o'clock. So I will see you then and see everybody else then too. Everybody have a very good night and a very good day tomorrow. Okay, and Monday and I will see you then.